Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. A little later on, we're going to talk about the success story that is Venezuela. But first, a real success story on Second Amendment issues. He bored you for the last half hour. Well, you thought he'd keep him over. Dave Kopel from the Independence Institute. How are you?
Doing great, thank you.
How long have you been doing CIO?
Since 1998.
Good God.
Which makes me the junior member of the cast. It's like, because Patty Calhoun started on it very early. So there were, like, Fritz Hollings would serve 5 terms in the Senate from South Carolina, but he was always the junior senator from South Carolina because Strom Thurmond had been since the Paleozoic era.
So if you knock her off, do you actually move into that chair? Is that the way that works?
Oh, absolutely, absolutely.
Right. Well, talk to Dominic, you could work something out. I wanted to talk to you about what you do during your real job, which is work on gun rights. And people don't get how important your role is as a Second Amendment scholar. It took me a long time to realize that you weren't just gold bricking, which I still think is half the time. But you've written some amicus briefs and some other legal journals that have had huge successes in the last couple weeks. I want to talk about those. First of all, the Ninth Circuit. What is the Ninth Circuit Court of Appeals? Where is that?
The Ninth Circuit Court of Appeals covers appeals from federal trial courts in all of the Pacific Coast states, all the way out, in fact, way Pacific Coast out to the territories, even including the Commonwealth of the Northern Mariana Islands, and also includes Nevada, Arizona, Idaho, and Montana.
The Ninth is not known for being a conservative court. I mean, the 10th District seems to be a bit more, the 10th Circuit. Ninth Circuit has kind of a California vibe, does it not? I mean, it's not always been hardcore originalist in most of its rulings.
No, but it's got a lot of judges. I think there are about 27 judges on active service there. So any 3-judge panel has a lot of potential for variety there.
All right. So getting to that, there were 2 rulings that came out, one in California, one in,
Well, one involving California, one involving Hawaii.
I was getting there.
Okay.
One in California, one in Hawaii.
Yeah.
Counselor, calm down. So let's take the one in California first, and what your work did in that one. What was at stake in California?
Okay, California last year passed a magazine confiscation law, saying if you have a magazine over 10 rounds, that's it. You can either move it out of the state, destroy it, turn it over to law enforcement, or that's it. But you cannot possess the property you legally bought years ago and you've never misused.
Was there some sort of compensation? I mean, since it's a taking, they
No.
didn't say, and when you turn in your magazine, we'll give you $20 for it.
No, and that was one of the issues in the case, is this is obviously it's a taking of property, and under the Fifth Amendment of the Constitution, taking a property requires just compensation.
So this 3-judge panel ruled what?
They upheld a decision that had been issued last year by a trial court, which put in an injunction, a preliminary injunction, and said, until this case is resolved, I'm going to issue a preliminary injunction because the need for it is so compelling. It's going to violate people's rights, and the plaintiffs are probably going to succeed on the merits. And besides that, we don't want to disturb the status quo. The people have their magazines now, and if we then allow the confiscation to go forward, and then it turns out the confiscation was illegal, well, it's going to be tough getting them their magazines back. So the trial court issued a preliminary injunction against the confiscation law, and recently a 3-judge panel of the Ninth Circuit Court of Appeals upheld the injunction and said district judges have great discretion in a preliminary injunction. We only review it to see if there was an abuse of discretion. And here on the facts, a different judge could have come to a different conclusion, but this judge's decision to issue the preliminary injunction was not an abuse of discretion. So the injunction stays in effect as the case now continues in the trial court, moving towards a final decision.
What was your role in this? Was yours an amicus brief, or was yours?
Yes, an amicus brief. I filed a brief on behalf of the Independence Institute, and I was joined by Joseph Greenlee, a young lawyer in Steamboat Springs who I often work with, and he represented the Millennial Policy Center. in Denver, and our brief talked about a variety of issues, but I think the one that turned out to be most relevant was the pro-con statistics on magazines.
What are the pro-con statistics on magazines?
Well, if you believe the Bloomberg lobby and their...
And I do.
Yeah, well, and so does a lot of the media, quite uncritically. They have these various claims that magazines over 10 rounds, they're used in mass shootings all the time, they're terrible, and all this kind of stuff. And our brief explained, well, no, actually not. When you look at their statistics, actually very few of the cases they talk about mass shootings even have a magazine over 10 rounds in them, for example. And we also talked about why people on the other side choose to own magazines over 10 rounds, because reserve capacity really is important for lawful self-defense.
So the issue of magazines, I always wondered about the 10 rounds. 10 rounds seems only because we have 10 digits. If we had 12 digits, it would be a 12-round magazine. Most modern guns take 15, 17, 19 rounds
Right.
for handguns. And in fact, Colorado's ridiculous 15-round ban makes it difficult to get dozens of guns now. When we said when this ban was going to come forward in 2013 that this basically meant a ban on certain firearms, it's true. I mean, you might be able to get a knockoff brand, but I'm not going to trust a knockoff brand for a magazine.
Nor should you.
Nor should you. And so Springfield and XDs and all sorts of other guns we can't get. Well, you can get it in Colorado, but you can't buy a magazine for it.
You can have the car, just not the tires.
Right, you have the car, just not the tires. Talk a little bit about the victory we had in 2000 over the 2013, in that there were some serious victories that the AG here agreed to because of the lawsuit you were involved in.
Well, sure, that was the Colorado sheriff's case, where I represented the sheriffs, and of course they were joined by other plaintiffs like the Colorado Farm Bureau, the Colorado Outfitters Association, Colorado Youth Outdoors, which helps families participate in the shooting sports. And over the course of that litigation, one of the things we got we succeeded in neutering, to a large degree, some of the worst parts of the 2013 Bloomberg magazine ban. One part said, okay, if you're a grandfathered owner, you have to keep the magazine in continuous possession. Well, and that meant...
Let me do that with my phone. I'll put it. It's in my possession.
Right. Well, and maybe it's okay if you have it at home and you're not carrying it around all the time, but suppose you take it to the phone repair store because it's broken. And then it's out of your possession and it's someone else's possession.
I do this. I go, hey, can you fix my magazine? We're now both criminals.
Right. That was what the continuous possession said. And essentially the litigation resulted in a different rule. You know, exactly how kosher that is against the statute could be debated. But it says, no, continuous possession is kept as long as you remain the legal owner.
There was another part of it, which was magazines could be a 15-round magazine, but I could take out the bottom plate, put an extender on, I did a quick video of this, and turn it into a 17-round, which meant it was readily changeable to...
Right. They said anything that was designed to be readily converted to be longer than 15. So exactly, you've got a 14-round magazine, but you theoretically could put a 2-round extender on it, even if you don't own a 2-round extender. The point was the magazine was designed to be able to be extended in that way, in the sense that it has a removable base plate for cleaning, and so necessarily you can add an extender. And so that was also changed by interpretation to mean, no, actually designed to be readily converted means it's fine until you actually have converted it. So if you got a 14 and you put a +2 on and now you have a 16, that's illegal.
Because as it was originally written in 2013, almost every magazine ever made would have been banned in Colorado because you can remove the base plate and you can put some type of extender on it.
That's right, except for some old-fashioned magazines. Most modern magazines can be disassembled, which you need to, like you might need to replace the spring or cleaned. And necessarily having a removable base plate means they can be extended theoretically to any capacity.
All right, so those were victories,
Yes.
But they're victories on the edges. I want to talk about another one you were involved with.
Well, I would say, but besides being a victory on the edge, that the design to be readily converted thing had actually shut down a lot of firearms commerce in Colorado because, say, Smith & Wesson, which, say, makes a handgun with a 13-round magazine, had stopped shipping to Colorado dealers because they said, we can't legally take the risk. We sell the dealer the gun with the 13-round magazine. Well, we know that somebody could put an aftermarket +3 on it and turn it into a 16, and so we're afraid to legally sell. And it was because we won those victories that firearms companies were able to resume the sale of ordinary firearms in Colorado.
Let's talk a little bit about this myth. And here's my suspicion. Tell me if it's founded. I don't think the Bloomberg types really care about magazine size. I think it is a way to nibble away at gun sales. Now that there are literally dozens of gun models I can no longer purchase in Colorado. They're illegal. They're useless. As you said, it's like buying a car, but you're not allowed to buy the tires. There are guns that come standard 17 rounds. They come standard 16 rounds, and that's it. This is a way to get to guns. This is not about magazines. This is a way to start taking guns.
Michael Bloomberg is advised by some of the smartest people in the country, in public relations, in strategy, and all that. And he's not only got his own groups, he puts a lot of money around the whole gun ban movement. And so there's a lot of collective intelligence on his side. And they recognize that you're not going to ban guns all at once. You need to go incrementally. But every time you can establish the principle of a ban, that's a foundation to establish the next step for the ban. So, for example, California was the first state to enact a 10-round magazine ban back in 2000. Well, it was not until 2016 were they able to get the political coalition together to confiscate the stuff, the grandfathered stuff, over 10 rounds. So, of course, that'll be proposed in Colorado whenever the Bloomberg lobby decides the political time is right.
Even though the magazines I have been grandfathered in.
By the 2013 law, they will end just like the California magazines were grandfathered in 2000.
Give it another 10.
Grandfathers don't stick around forever, and they'll try to terminate those grandfathers as fast as they can.
Someone was also arrested in California for actually registering his gun. Are you familiar with this case?
To some degree. California was the first state with a ban on so-called assault weapons, which is a completely bogus thing. Does not describe any category of guns that are really distinct from other guns. But anyway, they enacted their '89 ban, and they have expanded it by statute probably half a dozen times, and by regulation more and more times. So something that started off as, oh, this is just a few type of weird guns, is now a huge amount of very common guns. And it's very complicated and confusing. What exactly is legal, illegal, semi-legal? And so people who register end up finding out, oh, well, actually, your gun makes you a felon, which you bought legally, and you're trying to register and be a good guy and pay the enormous taxes California charges on those gun registrants.
Terrific. All right, spend a real quick minute here. We're over time, but the victory in Hawaii had a lot to do with your research and your work. What was the victory in Hawaii? In all places, Hawaii.
Well, Hawaii issues basically no concealed carry permits. There's maybe 4 in the state right now, and issues open carry permits only to professional security guards. The Ninth Circuit ruled that Hawaii's law that says the only person who can ever get an open carry permit is a security guard violates the Second Amendment, because the Second Amendment includes the individual right to bear arms, and an individual right needs to be exercised by ordinary individuals, not solely by individuals who are security guards.
Your role in that was what?
A very erudite opinion by Judge O'Scanlan cited a law review article I'd written about how Heller recognizes the right to keep and bear arms as a natural right.
All of this is to say that you're actually worth the massive salary you take.
I think I'm worth twice that, but I don't think I'm going to get a raise from you this Christmas, sir.
Well, we'll talk. All right,
okay.
Got to run. Congratulations. This is exciting stuff. Stay tuned.